5 seconds to go. Start. Thereupon, the respondent preferred a miscellaneous petition under Article 227 of the Constitution of India, which void the impugned order dated 4th July 2019 has been allowed primarily for the reason that the counsel for the appellant had applied and taken certified copy of the judgment dated 8th November 2016 in December 2016, which shows that the appellant was represented by his counsel even at that stage. The contention of the appellant that he acquired knowledge of the decree only after his release from custody on 6th May 2017 was wrong. In view of the aforesaid facts, the trial court should not have accepted the argument that the appellant and his counsel were not in communication during the period when the appellant was in judicial custody. Earlier, the application for reopening the defense evidence was filed by Parocar of the appellant. Having heard the counsel for the parties, we are clearly of the view that the impugned order is contrary to law and cannot be sustained for several reasons, but primarily for deviation from the limited jurisdiction exercised by the High Court under Article 227 of the Constitution of India. The High Court, exercising supervisory jurisdiction, does not act as a court of first appeal to reappreciate, reweigh the evidence or facts upon which the determination under challenge is based. Supervisory jurisdiction is not to correct every error of fact or even a legal flaw when the final finding is justified or can be supported. The High Court is not to substitute its own decision on facts and conclusion for that of the inferior court or tribunal. The jurisdiction exercised is in the nature of correctional jurisdiction to set right grave dereliction of duty or flagrant abuse, violation of fundamental principles of law or justice. The power under Article 227 is exercised sparingly in appropriate cases, like when there is no evidence at all to justify or the finding is so perverse that no reasonable person can possibly come to such a conclusion that the court or tribunal has come to. It is axiomatic that such discretionary relief must be exercised to ensure there is no miscarriage of justice. Explaining the scope of jurisdiction under Article 227, this court in Estrella Rubber versus Das Estate Private Limited has observed the scope and ambit of exercise of power and jurisdiction by a High Court under Article 227 of the Constitution of India is examined and explained in a number of decisions of this court. The exercise of power under this article involves a duty on the High Court to keep inferior courts and tribunals within the bounds of their authority and to see that they do the duty expected or required of them in a legal manner. The High Court is not vested with any unlimited prerogative to correct all kinds of hardship or wrong decisions made within the limits of the jurisdiction of the subordinate courts or tribunals, exercise of this power and interfering with the orders of the courts or tribunals is restricted to cases of serious dereliction of duty and flagrant violence of fundamental principles of law or justice, where, if the High Court does not interfere, a grave injustice remains uncorrected. It is also well settled that the High Court, while acting under this article, cannot exercise its power as an appellate court or substitute its own judgment in place of that of the subordinate court to correct an error which is not apparent on the face of the record. The High Court can set aside or ignore the findings of facts of an inferior court or tribunal if there is no evidence at all to justify, or the finding is so perverse that no reasonable person can possibly come to such a conclusion which the court or tribunal has come to. The factum that the counsel for the appellant had applied for the certified copy would show that the counsel for the appellant was aware that the ex parte decree had been passed on the account of failure to lead defense evidence. This would not, however, be a good ground and reason to set aside and substitute the opinion formed by the trial court that the appellant, being incarcerated, was unable to lead evidence, and another chance should be given to the appellant to lead defense evidence. The discretion exercised by the trial court in granting relief did not suffer from an error apparent on the face of the record, or was not a finding so perverse that it was unsupported by evidence to justify it. Stop.